right, it's Frank Portman again, and I'll be speaking on behalf of Ryan Conlon today, who unfortunately was unable to join us. Briefly on a new and interesting development in the law applicable to regulatory prosecutions, Health and Safety, Employment Standards Act, WSIA-related prosecutions, involving the charter right to trial within a reasonable time. And so Section 11B of the Charter guarantees this right to any Canadian. And most of the time we hear about it in the context of criminal offenses, but it's well established that it also applies to regulatory offenses, such as I mentioned, health and safety prosecutions, prosecutions under the Employment Standards Act, other provincial Offences Act prosecutions, all of which can equally give rise to the protection in Section 11B. The obvious question is, what is a reasonable time? And the courts have devised their own tests to determine this. And up until recently, the long-standing test was established in a series of cases. You'll see their names across the top there: Askov, Moore, and CIP, all of which will be very familiar to any lawyer who's had interactions with the criminal justice system or the regulatory prosecution system. And essentially what this old test required was that the court sort of parse the amount of time that it took for a matter to get to trial and figure out, okay, we've got a certain amount of time that it took. Who's responsible for each part of that time that this took to get to trial? Is it the Crown's fault? Did the Crown do something that was going to lead to this delay? Did some things the defense do contribute to the delay? Was it the system itself that was at fault here? And so basically there was this real complex, very minute accounting test that the court used to determine whether or not the right was breached. And ultimately ultimately under this old regime, the court would look at, well, do we have a situation here where the time it took for this matter to get to trial was just completely unreasonable? And specifically with respect to corporations, the Supreme Court in the third decision highlighted on this slide, CIP, said, this applies to corporations too for a number of legal technical reasons. We can see no reason that this right wouldn't apply to corporations just as it would apply to an individual. But it applies differently. The reason it applies differently is when you've got an individual who's charged, eventually a delay just reaches the point where the court says, look, this is too long, that this right has been breached just by the mere fact that it's taken so long for this thing to get to trial. You don't have to prove that it had some sort of negative impact on you. We're just going to presume that it did because it's taken so long where you've been under this indictment. But corporations don't get the benefit of that presumption. Instead, they have to prove that somehow their right to a fair trial was prejudiced by the passage of time. So you can think of something like the deterioration of evidence over time, the inaccessibility of witnesses. These are all theoretical things that corporations could use to show that their right was breached. But effectively, this became impossible in most cases. Proving prejudice became incredibly difficult, and in a lot of cases, it really made the right as it applied to corporations kind of empty from a practical standpoint. This is important because the right in Canada, if your right to a trial within a reasonable time under Section 11B is breached, then the presumptive remedy is a stay of proceedings. In other words, the charges are stopped dead in their tracks and the Crown cannot press new charges afterwards. It has the effect of an acquittal, although legally it's a slightly different concept. So this is the old regime. But in July of this year, or last year rather, the Supreme Court said, we've looked at this old regime and we've had enough. We don't think it works anymore. This was in a couple of cases called Jordan and Williamson, but mostly it's referred to as the Jordan test. Basically, the Supreme Court says, look, the old framework is unpredictable, it's unwieldy. What prejudice is can change. The same court on a different day may find that something is prejudicial and on a different day may find that it is not. So it's really unpredictable, it's unwieldy. We've got to simplify this process, and the way that they do that is by saying, you know what, we've looked at all the factors and we say there's a bright line, and it should take this long for a case to go to trial, for a case to finish trial after the information is sworn and charges are laid. And in provincial court, that time period is 18 months. That's longer in Superior Court, but the 18 months is what's going to be applicable to regulatory offenses, as well as really anything that appears in front of the provincial court. So you've got this bright line test, 18 months. And once you breach that, there is no sort of step-by-step accounting. It's quite simple. Once that cap is exceeded, there's a presumptive breach of 11B rights, and there's a presumptive stay unless the Crown can show that some factor exists that means the cap shouldn't apply. And those factors are limited, right? It can exist in a case where a defendant says, no, I'm going to waive my right to a trial within a reasonable time, and that can be done by conduct. But there are some other exceptions for extraordinarily complex cases, for extraordinary events that delay a trial. There's also, interestingly, this transitional exception that applies to cases that are already in the system. So even if the information in a case was laid prior to July of 2016 when Jordan was released, the new test is still applicable to that matter. It's just that we have to look at it slightly differently, the court says. The court says we're going to instead look at, were they relying on the old system? Because if they were relying on the old system, if the Crown was relying on it, if the defense was relying on it, then it doesn't really make sense for us to stay just because we imported a new test that really no one was predicting. So, but this left a question, right? We've got these cases. Jordan involved an individual in a drug trafficking ring. Williamson involved someone charged with historic offenses. So these are both individuals charged with criminal offenses. So the question remained, how does this impact a corporation's rights under Section 11B? Because some of the language used by the court in Jordan suggested that maybe corporations have new protections too. And this has been tested in a couple of cases, which should give some encouragement to employers that indeed that right has become easier to actually enforce. And the first case is the case of R and Live Nation. And Live Nation involved the collapse of the stage at a Radiohead concert in Toronto in 2012. There were a few different defendants, all of whom were charged with various breaches of the Occupational Health and Safety Act, many of whom were corporations. This motion was brought, and at the time, the anticipated end of trial is 42 months after the information is sworn. And that's well outside of the Jordan guidelines, well after the 18 months in which Jordan says this matter should have been not just brought to trial, but the trial should have been finished. And so the court started, and this is Justice Nakatsuri, who's very well respected on constitutional matters, and definitively said Jordan applies to corporations and it applies to provincial offense proceedings. And this was a big moment because this is the first time we have a court saying, yes, the old test is completely thrown out, including how it applies to corporations. Jordan is now the rule as it applies to corporations. But in this case, there wasn't a breach. The reason there wasn't a breach was because this case actually met a couple of those exceptions I discussed earlier. First of all, it was exceptionally complex. We were looking at lots of expert evidence. There was going to be 9 weeks of trial, multiple defendants. This was an unavoidably complex case. And the transitional exception also applied. The court said, look, the Crown had a plan. They tried to keep things moving. There was a couple of points where the Crown made some misjudgments that led to longer periods of time. But by and large, under the old system, they were going to be able to show that they were really trying to push this thing forward. And so under the transitional exception, as well as the exceptionally complex case exception, the court said, yeah, you've got the right, but in this case, it's not breached just because of these specific circumstances. You're within these exceptions. So that's an important building block, but it wasn't quite the outcome that employers would have wanted because we haven't as of yet seen a stay against a corporation under the Jordan test. However, that changed shortly thereafter in a case that was released, although not yet published, called R and Fitness 1 and some other entities. And full disclosure, this case was argued by Jeremy Schwartz of our firm. In this case, this involved charges under prosecutions, rather, under the Employment Standards Act against an individual and a multitude of corporations who were charged with failure to pay orders issued by the Director of Employment Standards. So essentially, these were unpaid wages that had been orders had been issued to collect these unpaid wages, and the accused were accused of not fulfilling the orders as they were required to do. And so in this case, the application was brought we were looking at about 22 months between the information being sworn and the first trial date. And the anticipated end of trial was about after 27 months, although it was really the 22-month period that was really foremost in the court's mind. So there was a few wrinkles in this case. First of all, that up until the very end of the proceeding, the defendants were self-represented. And so the defendants, through the director, the individual accused, represented themselves at the earlier hearings. And the pretrial, there were 3 different judicial pretrials scheduled. And throughout that process, these defendants were self-represented. And the court found that nowhere in that period did the Crown and the court come and inform the self-represented litigant of their rights to a speedy trial, that this wasn't an exceptionally complex case. In fact, it was mostly a paper case. The Crown said they could pretty much prove that they alleged that they could make their case solely by introducing documents. So not particularly complex. And the court in this instance found, look, Jordan applies to corporations, in this case, very much echoing Live Nation in terms of why the new threshold applies. They found no reason to relieve against it in the case of either the individual or the corporations. In fact, the court found no reason whatsoever to apply the test any differently to corporations than individuals, which of course represents a significant departure from the old regime. So that's a very important case for employers who are charged with these offenses. It means that employers will be able to defend themselves against these charges in a quicker manner, that there's some incentive to have these matters move along and dealt with in a speedy process. Now, we've already seen changes in terms of judicial resources being moved around to avoid the prospect of charges being stayed. In Toronto, some justices have been moved off of civil matters to deal with criminal matters to avoid the problem of these Jordan timelines. Now, this is not likely to be the final say on the matter. It's likely that this is going to be litigated in higher courts, and it's likely that the Court of Appeal and perhaps even the Supreme Court itself is likely to want to weigh in on exactly how Jordan applies to corporations, whether it just applies that the test is identical, or whether or not, as held in CIP, we should consider different factors. But it does appear likely that, at least to some degree, corporations will be protected against protracted litigation to a greater degree than they were prior to Jordan. So we're likely going to see these prosecutions moving along a lot quicker. We're going to see the Crown take them on with a greater sense of alacrity, of urgency, and that's going to, regardless of whether there's different interpretations from higher courts, we suspect that that's likely to be the result of the decision. So with that, I will turn the